listening to Let's Get Surety. Let me hear your bonding talk with Kat Shamapande.
Hey everyone, it's Kat Shamapande. Thanks for joining us for this episode of Let's Get Surety. I have my co-hosts here with me today, Mark McCallum, CEO of NASBP. Hey Mark.
Hi Kat, always good to be with you.
Yeah, excited about today's topic. I'm sure many of our listeners have seen disputes arise at the end of a project between subcontractors and general contractors regarding offsets. On this episode, we're going to be talking through what offsets are and limiting the right to offsets. So to do that today, we have with us Lauren McLaughlin, a partner at Smith Curry, and Roz Andikin, an associate with Smith Curry. So thanks so much for joining us, Lauren and Roz.
Thank you. It's great to be here.
Great. So before we get started and kind of dive into this issue of offsets, can you guys tell us a little bit more about Smith Curry?
Sure. Smith Curry is actually the one of the largest construction law firms in the country. This is all we do, coast to coast. We have offices headquartered in Atlanta. We have over 60 attorneys. We have offices in San Francisco, D.C. We're inside the Beltway here in Tyson's Corner. We have offices in Florida, South Carolina, North Carolina. And all we do is construction and surety. So delighted to be here today to talk about our favorite thing.
We're glad to have you. So can you guys explain to us what are offsets? I think that's a great place to start.
Sure, Roz, if you don't mind, I'll go up to bat first.
Absolutely.
I think that we know on construction projects, you can have general contractors and subs who often have multiple contracts on different projects, right? The construction industry is about not only building projects, but about building relationships. So subcontractors want to make very good clients with GCs in the area. So they'll work on different projects in different areas with the same parties. And so oftentimes when all goes well on a project, you don't have any problems. Oftentimes, however, and all too often, you can have a project go well in one area, and the work is performed, payment applications are submitted and approved, payments are made, everything goes great. So everything's smooth and both parties make money on one job. But sometimes another project is mired in claims and disputes, right? You've got the same people, but they like each other on one project and they're not working well together on the other.
Yeah.
And so offset comes up when the GC says, hey, I know you're owed money on the job that's going well, but I think you owe me on money on project B. And I'm going to take that and not pay you on the good project because I think I need to basically do a global accounting here and make sure we're square on all of our projects. And I'm going to withhold money on another job for the money I owe you on this job.
Where would you look? Oh, go ahead, Mark.
Oh, I was going to say, so that right of offset, is that something that the law provides or the contract or both?
So it's a great question. Offset is a right that is established by contract. So all GCs, all general contractors and owners will want to put in their contracts language specifically granting them the right to do that, to withhold money from one job that's going well with monies that are owed on a job that they believe are not going well. So they can establish that offset right by contract. But the other way they can establish it, and this is sort of a lesser known right, is through state court procedural rules. And that sounds weird, but let me explain briefly. It's essentially when two parties go to court and they say, I want to sue you because you owe me money. Well, a lot of state court procedural rules allow the party who's being sued to defend that suit by saying, well, wait a second, you owe me money also. And so the parties, oftentimes general contractors, if they're sued by a sub for money owed on one project, they'll just use the offset right in the court system, right? In the sort of litigation procedural realm. So you've got offset by contract and offset by procedural legal rules.
So it sounds a little bit like maybe there's a policy behind it for efficiency in terms of the litigation.
Exactly. That's what courts do. They want to say, look, we don't want a lot of lawsuits here. We don't want to have you all filing different cases. If you've got many fights against each other, then bring them all in one spot. We want to hear all of them here in one suit.
Okay. So maybe then, as the old adage goes, what's good for the goose is good for the gander. So can that be used as a double-edged sword?
Well, I think that's a pretty poignant. I mean, I think that, to use another analogy, we've established the grounds for offset, that it can be by contract or it can be by state court rules. But I think offset can be, limited to an extent, death by 1,000 cuts. There are a number of ways that they can be limited.
Well, I imagine as the economy is changing and there might be paucity of financing, or maybe the funds might not have been there after all. Do you think that we'll see parties trying to exercise their set-off rights more and more in the coming months?
I think so. I think there's no question that, we've all, I'm going to assume we've all on this podcast been around long enough to know what happens when the economy gets tight, just like 2008. And what we see is increased litigation because parties are fighting over money more, right? When the economy's not doing well. Right. And when they do that, you're absolutely right, Mark, that the parties go to their contract to pull out every stop and every right that they have to keep the money.
And if you were going to characterize, maybe Roz, what a typical language in a contract that would either permit it or limit it, could you kind of maybe go over a little bit of that?
Sure, Mark. We wrote on the subject, and in our article I did quote a contract language. I'm happy to read it to the listeners. So a typical set-off offset clause would sound something like this. A contractor may withhold amounts otherwise due under this subcontract or any other agreement between the parties to cover contractor's reasonable estimate of any costs or liability contractor has incurred or may incur for which subcontractor may be responsible under this subcontract or any other agreement between the parties. And as Lauren alluded to in the beginning, you're not just building projects, you're building relationships. So a lot of times, the people that you're working with, you tend to work with the same parties. So it's very common for big general contractors to have language such as the one I just read, because you're always working with the same people, and that's where offset can be used as a sword or a shield, depending on who you are, whether you're the sub or you're the GC.
Right.
Wow.
So is offset put into place or affecting public and private work the same way, or is it different?
Well, I think, mostly when you're dealing with, we'll call them the sovereign, when you're dealing with federal projects, the right of offset is solidified, codified, if you will. In the federal acquisition regulations in the FAR, the government can always offset, right? And that's something that's resolute, and that's sort of that goes down to state projects as well. Typically, state owners, you do have the right to offset, and GCs on those projects also typically have the right of offset. Whereas private projects, and I'm sure we'll get into this a little bit later, there are ways to limit and disallow and void that right.
So, in terms of like jurisdictions around your office where you practice, which would I guess be Maryland, Virginia, D.C., are they pretty much in alignment, or are they different in terms of how they recognize the right to set off?
I can take, there's 3 jurisdictions, so I'm happy to take one of them. So I guess I'll start with Maryland, because there's been some new development in Virginia, and I'm sure Lauren can get into that more in a minute. So Maryland has what we call a trust. It's a construction trust fund statute. And I guess this might become a little bit of a longer conversation. So a trust fund statute, especially in Maryland, it applies to both public and private projects. And the statute requires that any funds paid under a contract by an owner to a contractor, or an owner or contractor to a subcontractor, gets held in a trust for those subcontractors that did work on that specific project. So this essentially means you can't have that global accounting that Lauren mentioned in the beginning, where if you're a subcontractor that works for one GC on several projects, this requires that if you're working for project A, you will be paid for project A through the trust fund. And that's why they exist. Just some background, that Maryland is one of actually 15 states in the United States that has a trust fund statute. The other ones, I'll just mention them. I won't go into what they are, but Colorado has one, Delaware, Illinois, Michigan, Minnesota. New Jersey actually has 2 trust fund statutes, one for private and one for public. So they've actually differentiated between the 2. New York, Oklahoma, South Carolina, South Dakota, Texas, Vermont, Washington, and Wisconsin. And so that's a little bit about what Maryland does specifically. So offset's not allowed in Maryland because there is a construction trust fund statute that requires projects to be paid specifically for that project. And now Lauren will talk about Virginia.
Right. I think so. It's a great question to say, like, well, there are a lot of subcontractors in this, where you have a multi-jurisdictional practice. A sub working in Maryland is going to work in DC and Virginia and Maryland, right? And so they're in alignment, Mark, now, as of July 1st, 2020, with a new Virginia statute, that offset is now no longer allowed on private projects in Virginia. And that's now in line with Maryland. DC doesn't have a statute limiting offset. And so if you've got, if offset is in a contract and in their state court rules, that's going to be allowed in DC. Although I will tell you that, there is these subcontractor lobbying efforts in different jurisdictions is going to go forward in DC to have this, legislation limiting offset in DC as well. So I think the answer to your question is that there will be complete alignment at some point, but right now it's Virginia and Maryland. It's not allowed, and DC it is.
Great. Thank you for that.
So it sounds like there might be a change in the tide, or the winds might be blowing towards limiting offset in more jurisdictions. Is that right?
I think that's right, Kat. I think, we talked about how offset is granted. And when you talk about, the winds blowing to limit offset, it happens in a number of ways. It happens through construction trust fund statutes that Roz spoke to, where you essentially put on the state statute, put in the books that monies that are owed on a project must be held in trust for the subs on that job. That makes the owners and the GCs trustees, and the subs and suppliers beneficiaries of that money. And there, it depends on all the different states, but there can be criminal liability for not paying a sub on a job with that, with the money that was given by the owner, or there can be civil liability. So you can offset can be limited through construction trust fund statutes. It can be limited through new legislation, such as the one that was in effect in Virginia as of July 1, 2020, a judicially created law. It's not a construction trust fund statute, but it just says, hey, if you have an offset provision in your contract, guess what? We're going to read it as if it's not there. Even though you sophisticated parties sat down and bargained for and negotiated for that term, we, as a matter of public policy in Virginia, are going to read it out of your contract. We're going to say it's void as to public policy. And that's huge because Virginia is a jurisdiction where contract is king, and essentially whatever parties agree to, it's going to be enforced as written, but not this time. The subcontractor and supplier lobby got together and said, let's try to limit offset. We're not going to call it a construction trust fund statute because the GC lobby, the AGC and ABC and all the industry groups representing general contractors won't, we don't think we can politically pass that, but let's try to call it something different. So you can have offset limited again through construction trust fund statutes, through statutes that find offset void as to public policy. You can even have offset limited by things like the contract. I mean, a pay when paid provision can be viewed as limiting the right of offset. Prompt payment statutes and bond language, as I'm sure you and Mark know. I mean, the surety industry specifically crafted paragraphs to the AIA A312 2010 versions, both the performance and payment bonds, to say, hey, you can't offset monies owed to sureties that the surety is going to, any contract balances that the surety is entitled to, no offsets.
And I imagine with the specter of some bankruptcies out there that how does an offset work in relation to an automatic stay? Can you enlighten us on that?
That's a great question. I think, that has been litigated with mixed results. Sometimes an automatic stay allowing a debtor to, allowing the debtor protection under the bankruptcy code, the offset is going to be trumped, if you will, by rights afforded under the bankruptcy code. And then you've got other issues such as equitable subrogation and how Miller Act rights play into the bankruptcy setting if you're seeking to go after the debtor despite the automatic stay.
Right. Well, I imagine where set-off rights do exist and there's a default and the sureties involved, those would be, in certain circumstances, valuable rights that the surety has. Can you explain maybe in a typical situation that you see, how the surety may use those rights?
Sure. I think they can use, it's like 4 different ways it can come up. Sometimes it seems they can use it as a shield and as a sword, as you alluded to earlier. A surety who is acting as a payment bond surety for the GC, they are going to want to use the offset right by contract when they get payment bond claims from the GC subs.
Right.
They're going to use that they're going to use the offset provision and say, hey, I step into the shoes of my principal. My principal has an offset clause. And so I can use that as a defense sub to your payment bond claim. And, we've seen cases both where the surety has succeeded in that. In particular, I'm thinking of a case out of Pennsylvania. And we've seen situations where a surety has lost when they try to do that. Thinking of, somewhat recent one in the Eastern District of Virginia, where the court said, look, even though the right of offset is in that contract, and even though you're the payment bond surety, and you've made payments, so you're equitably subrogated, you know what? We think this supplier's Miller Act rights trump your principal's contract offset right?
Very interesting. It sounds like more and more with, you say, the activity that's been going on, it really behooves contractors and subcontractors to get the advice of knowledgeable counsel to know whether or not and how offset rights are limited. What are some of the factors that those parties should know about offset?
Well, if I may, Mark, real quickly, I wanted to jump back to the previous question, because I also wanted to mention, the sword part, right? The sureties can also use offset as a sword if they are a completing surety, right? If their subcontractor defaults or their GC principal defaults, and they come in as the completion contractor, they come in as the completing surety. They want to make sure that their rights to the contract balance are not offset by claims on other bonded or non-bonded projects. And so we've seen, cases that say, yes, surety, you know what, you're coming in as the completing surety, and it's not. We don't think that the law allows somebody to offset non-bonded projects, right? Disputes on non-bonded projects with your bonded contract proceeds that you're entitled to as the completing surety. So, right. So I just wanted to circle back on that, where sureties can use that offset as a sword and prevail. And as to your point, pick me up again to where you were, to what, you wanted me to speak to the issue of what kinds of issues should clients be mindful of in
explore with their legal counsel on offset.
Yeah.
Sure. I mean, I think there's a number of items that parties need to be aware of, right? They need to make sure that, what does the contract say about offset? Is it silent, or does it grant the right? You want to have, counsel carefully consider what language is granted or not granted in both the contracts and the bonds. And you want to know what what jurisdiction you're in. I mean, how is offset handled in your jurisdiction? Are you, as Roz mentioned, one of the 20 states that have a construction trust fund statute that sort of protect at all costs that those contract proceeds from offset? Or are you in one of those 30 states that don't have one? So again, think about the balance. There's more places in the United States that don't have a construction trust fund statute than do.
Right.
Are you in a jurisdiction that allows, as you pointed out, Mark, what's good for the goose, it's good for the gander? Are you going to allow offset anyway because you're litigating against each other? And then getting into the nuts and bolts, not only of the contract, do you have an offset provision or not? It's not that easy, but do you have a pay when paid provision or a pay if paid provision that's going to, in some respects, limit the contractor from offsetting, right? And so, or do you have a prompt payment statute in your jurisdiction that says, and Kat, to your point on public projects, is there a prompt payment statute that says the monies paid by the owner must be promptly paid by the GC within 7 days or 15 days to the people who are working on this project? And as we talk about trends and the winds blowing, I mean, Virginia, is one state now who no longer, I said 30 states that don't have a construction trust fund statute, but now Virginia is one that has sort of a cousin of that, right? They've got a void by public policy. We're not going to enforce offset clauses in this state. California is another one. In 2018, the California Supreme Court decided that the only time that funds can be withheld on a contract is when there's a dispute involving that particular scope of work. And what was interesting is that even though the decision didn't reference offset, all the California construction lawyers knew exactly what it meant, which is that this now ends the traditional use of offset by GCs in California. So, you've got a lot of statutory and lobbying efforts and laws that are being implemented and contract clauses that are eating away and eroding the right of offset. And I guess depending on which side you're on, that's a good thing or a bad thing. And
right.
As you pointed out, depending on what hat the surety's wearing, that's a good thing or a bad thing.
What's kind of interesting, and I may go a little bit on a tangent, and so I'll give you a fair warning, but it seems like a trend is going on with kind of wage compliance, making the GC responsible for wage payment by lower tier contractors and subcontractors. And then now you're saying there's a trend about, limiting offset. Do you see those in conflict?
That's a great question. And it's very interesting because I absolutely have seen the former, in which you described GCs being liable for wage compliance. I would not say that I see that in conflict with the trend to limit offset. I think that there are effective lobby groups that try to, lobby what they see as injustice, right? And so,
right.
I can't say that I would feel that was unright or unjust, that the GCs are kind of, taking it in the chin, taking it on the chin in both regards, right?
Right. Fair enough. Well, Roz, if you wanted to leave bond producers with what else they need to know, certainly they're not attorneys, but they do get asked questions a lot by their clients. What would be the one thing you'd want them to know about offsets?
You said just bond
producers,
bond producers.
Right.
I would say, as Lauren mentioned before, you always have to check your contracts, right? You always have, if you're a bond producer, you want to look at your bond, look at your language. What are you going to limit or not limit, right? And as Lauren mentioned before, and what we've been talking about, offset is a contractual right that you create, or it could be through state rules. But I guess in terms of a bond, it's really, what does your bond say? That's what I would leave them with. And I think I did a post about this, I think a while ago, a blog about bond rights, and just knowing what your bond says is so important. And I think that's what I will leave it with.
Right. They need to be good issue spotters, and to make sure that they direct their clients to knowledgeable professionals and counsel, right? So
absolutely. That's exactly what I would say. I mean, it's really important to know where you are, where is your project, what jurisdiction controls, and like we said, trust fund statutes they're not all over the country, but you need to know where you are and who you're working with to figure out what law applies.
Well, that's excellent advice and a lot of great information. We really thank you for this podcast, and look forward to talking to you in the future.
And I want to jump in and let the audience know, Lauren and Roz, they can find out more about this topic in an article that you guys wrote for the Smith Curry newsletter, Common Sense Contract Law. We'll include a link in the description if anyone wants to read up a little bit more on this issue. Thanks so much.
Yeah, yes. We're delighted to be here. Thanks, guys.
Thank you so much.
You've been listening to Let's Get Surety, brought to you by the National Association of Surety Bond Producers. For more information about the NASBP and its members, visit nasbp.org.